When I tell you it is my goal to make you the smartest person in the room ahead of everyone else when it comes to our Second Amendment right to keep and bear arms, I'm not just kidding. I literally mean it. And I want to prove to you how so this is true right here and right now with this video. Because the New York Times has just demonstrated that if you've been watching my videos the whole time, you are smarter than the New York Times and the people in it. Stay tuned. We'll talk about it when we get back. Hey folks, it's Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms, and feel free to join us on Twitter as well. Okay, folks. So the New York Times just published an article entitled, "In the Gun Law Fights of 2023, A Need for Experts on the Weapons of 1791. Well, aside from the fact that that title is actually inaccurate in terms of what's needed, set that issue aside, the point is that the whole discussion of this article, which I'll link to down below, by the New York Times in March of 2023, is about how the anti-gunners are trying to bring out experts to reinterpret American history and American law, going all the way back, as an attempt to justify what I view to be unconstitutional modern-day gun control laws. Now, the reason why I led off this video by saying that it is my goal to make you who watch these videos the smartest people in the room when it comes to your right to keep and bear arms. I mean that I literally want you to be the smartest person in the room, even if that room consists of PhDs and fancy lawyers and judges and intellectual giants. I want you to be the smartest, and I think I can help you get there. Give you an example. This article was published by the New York Times in March of 2023 talking about historians supposedly needed, to deal with modern-day gun control cases. Now, we covered this in extreme detail in November 2nd of 2022, which meant that if you've been watching my videos, you were literally about 6 months ahead of the New York Times and what's coming down the pike involving the Second Amendment and Second Amendment litigations. You're literally 6 months ahead of the so-called paper of record. I know we all make fun of the New York Times, and it's justified. And the New York Times is a bunch of liberals, all true, we get that. With that said, I just want to illustrate the point that I am generally ahead, out in front of the game, and I do that, and I work hard to be out in front of the game to benefit you, so you guys are out in front of the game, because we need to be out in front of the game when it comes to our right to keep and bear arms, because they're trying to take away our rights at every chance they get. Now, so let's talk specifically about the New York Times article and why I think it's not accurately written in my view. There's nothing defamatory or anything terrible or illegal in there, but I think it's not quite telling the whole story. And I'm not going to blame the writer here, because if you look at who they appear to have interviewed, in my view, most of the people they interviewed were really on the gun controller side. So, they certainly didn't call me up to interview me. So that probably would have helped their article. Had they spoken with me, I probably could have improved the quality of their article. But again, we'll never know because they didn't call me. So let's continue on and talk specifically about what the New York Times article on the need for historians said, the need for historians to interpret modern-day gun control laws. Keep in mind, none of this is needed. Let's be very clear about this. The U.S. Supreme Court in Nyserpa versus Bruen says that if the plain text covers a particular modern-day gun control law, it is presumptively unconstitutional and may not be enforced. The only so-called exception to that, or narrowing of the scope of your right to keep and bear arms, can possibly exist that in the year of our Lord 1791, which is when the Second Amendment went into effect, there were certain gun control laws that were in place then that continued on to this day. A classic one I like to give is that in 1791, you could not misuse firearms to commit murder, rape, or robbery. That was a classic example of, even though you have a right to keep and bear arms, you weren't allowed to use your right to keep and bear arms and firearms to commit malum in se, violent crimes. That was a misuse of firearms. That has been not permitted from before the founding of our country all the way through today. That's the sort of thing that the Supreme Court is looking to see, whether or not there's something like that out there that narrows the scope of the Second Amendment, because again, you cannot misuse firearms to commit violent crimes like that. That's what we're talking about here. But if you look at what the anti-gunners are doing, and I predicted this all the way back in the fall, that the anti-gunners are trying to use their overwhelming power and influence and money in American academia, which they control, and in the public health schools, which they also control by and large, to simply overwhelm. Their goal is to overwhelm the court system with quote-unquote experts in history to try to rewrite American history as I see it. Keep in mind that all this takes place in light of a recent story I told you that I wanted you to know about, and it's now coming back. That was the story of the historian from Emory University, Michael Bellesiles. If you recall, Michael Bellesiles was a historian at Emory University. He wrote a very famous, now infamous book called Arming America, where he basically said that the United States at the founding was not a gun culture. It actually was a myth. It wasn't true, and he supposedly proffered all sorts of historical evidence in support of it. This became such a big deal in the academic anti-gun community that he ultimately won the famous Bancroft Award, awarded by historians at Columbia University. The Bancroft Award is the most important award you can win as a historian in the United States. He won it, but because it turned out a lot of his research was not accurate and was faulty, believe it or not, I think in the only time in American history the Columbia University trustees of the Bancroft Award actually revoked his award and took it back from him on the grounds that indeed Michael Bellesiles, who wrote Arming America, and again arguing that gun culture was a myth, that work he had done was simply not credible, and he lost his award after he had been awarded initially one and only time in American history this had ever occurred. Surprisingly, the New York Times does not tell the story about that anti-gun historian Michael Bellesiles and Arming America in this article. I wonder why. But let us go on and talk about some of the other things they say in this article. We've rebutted these points, and a lot of silly points here, but I want you to know the truth. Remember, they talk about Judge Reeves. Now, you remember Judge Reeves from Mississippi. He's the one back in November I did the first story on, explaining that this is where the anti-gunners are going to go. Judge Reeves says that because he's not a historian, he's not capable of interpreting the Second Amendment without professional Second Amendment historians, which is basically just an excuse to outsource his decision-making about what the Constitution means and to apply it to people that likely don't like the Second Amendment. But Judge Reeves was not only attacked robustly by the Four Boxes Diner in this video, he was also attacked in many other academic quarters, and not least of which was the Joe Biden Department of Justice actually submitted a brief in front of Judge Reeves in that Mississippi case that he was talking about and said that we, the Department of Justice for Joe Biden, don't feel the need for experts to interpret the Second Amendment because, after all, it is our job as lawyers and your job as a judge. Your job, indeed, is to interpret the Second Amendment. Why would you hire someone to teach you how to interpret the law when your job is to interpret the law, and you swore an oath to uphold the United States Constitution, including the Second Amendment? And if you're not capable of understanding what that means and applying it as a federal judge, maybe you should step aside. And obviously that was the gist of all the arguments against this notion that a judge needs to appoint a historian to teach them about history. But anyway, none of it really matters, because the Supreme Court in NYSERPA versus Bruen says our job is not to understand history for the purposes of some History 101 exam in college. The purpose of it is to identify historical analog laws. Do you see what I'm saying? You see the distinction? The anti-gunners want to appoint historians to tell fables, to tell stories, to change the narrative about the trajectory, the trends in American life and American history. Nah, not what you're supposed to do under the Second Amendment, under the Supreme Court's precedent in NYSERPA versus Bruen, because what the Supreme Court said was we don't want about trends in history or standing on the banks of history and seeing it pass by. No, that's not the standard. That's not relevant. What the Supreme Court said in NYSERPA versus Bruen was that judges are to look specifically at the time of our founding in 1791 when the Second Amendment was adopted. Are there specific historical analog laws or regulations that were on the books and enforced This suggests that there was limitations to some degree on the right to keep and bear arms. So you're really looking for laws, not narratives, not storytelling. You're looking for specific laws that had specific meaning at a specific time in American history. And this is not that hard. Keep in mind that people have been studying the United States Constitution and American history for over 200 plus years at the time of the founding. There are professors of American history going back 200 plus years that have been looking at what John Adams wrote, what Thomas Jefferson wrote, what George Washington wrote, decisions by James Madison, and so on and so on. So it's not as if today, oh my God, we now need to learn about our founding fathers and the Bill of Rights. Come on, we've been doing this for over 200 years. This is not exactly a new process. So to suggest, like the New York Times does, is we now need experts to come teach us about this crazy area of the law, the Second Amendment, the Bill of Rights. We never thought about this before. It's stupid. Stupid, right? We've been learning, we've been talking about this for 200 plus years, and people have been studying this in the Ivy Leagues and beyond for over 200 years. So it's not like it's new. Beyond that, keep in mind, now, have you ever filed your tax returns? Think about this for a second. When you file your tax returns, you have to sign that says that everything I've just submitted to the IRS is true and accurate to the best of my ability, to the best of my knowledge, and so on. When you file, if you run a business and you file something with the Securities and Exchange Commission or a government agency, again, you have to swear on the dotted line that what you're saying is true and the information contained in that document is true and accurate, right? You got to do all of that, right? Got to do all that. So here's my point. When the legislators of the United States in the states and Congress pass laws that regulate guns, they basically are signing off on the fact that they have done their homework, they've assessed the constitutional considerations, they determine whether or not it's constitutional or not, and they are signing off on the fact that in our view, based on the research that we have done, that the gun control law we're about to pass is constitutional under the text of the Second Amendment and all available legal precedents. That is what they're signing off on before they pass the bill. So it's very interesting that here in this New York Times article, they're saying like, all these Democratic attorney generals are rushing out to find experts to justify these anti-gun laws. My point, of course, is that they had to do this work ahead of time, not after the fact. You're supposed to have already hired these people and made sure that your law that you were enacting was constitutional, as opposed to what's going on now, which is they passed all these unconstitutional laws, and now these anti-gun politicians are scrambling to try to find historians to justify what they did after the fact. Okay, to excuse their behavior that is likely unconstitutional. That's what's really going on here. But let me continue and talk more about some of the silliness in this New York Times article. Specifically, they say that NYSERPA versus Bruen dramatically changed the standard of the Supreme Court Second Amendment precedent, that it quote-unquote upended it. This is not true. What NYSERPA versus Bruen did was not upend Second Amendment jurisprudence. It simply told those lower courts in the blue states of New York, those judges in New York and California and New Jersey and Illinois and the like, that they needed to get their act together, and they needed to follow the rulings as set down by the Heller decision in 2008, McDonald in 2010, and Caetano in 2016, and to get their act together and to stop doing interest balancing tests, which every time you hear the words tiers of scrutiny, that is a euphemism for balancing away our rights in favor of government, so-called government interest, taking away our rights. And the Supreme Court said, stop that, lower courts, stop that. That is not upending Supreme Court Second Amendment law. What that is really doing, the Supreme Court, is spanking the anti-gun courts in these blue jurisdictions, and yet the New York Times talks about upending lower court jurisprudence. It wasn't upending lower court jurisprudence. It was spanking them and making sure that they follow the law as inferior courts to what the Supreme Court has said about the right to keep and bear arms and the rest of the Bill of Rights. That's what's really going on here. So when the New York Times article talks about dramatically shifted the standard and upended longstanding stuff, it's all fake. It's not true. The bottom line was you had a whole bunch of lower courts who were not following Supreme Court precedent, and they got spanked over it, and that is what should have been in this New York Times article right here and right now. The next thing is there's a whole bunch of article discussions in this New York Times article about having to study guns at the time of our founding. They talk about, the Girandoni air rifle, which they call a novelty gun. They may want to talk to the Austrian army that actually used this quote-unquote novelty gun, and the fact that the Girandoni air rifle kept Lewis and Clark alive when they crossed the country and faced things like grizzly bears and hostile Indians and so on. But nevertheless, that doesn't appear to, as far as I can tell, that's not appearing in this New York Times article. Nevertheless, as you know, it doesn't matter about these guns at the time of the founding, because the Supreme Court says we're not limited to just muskets and dueling pistols in modern day America. The only thing that matters as to whether or not you can ban things like an AR-15 or a semi-automatic AK-47, the only thing that matters is in 21st century America in 2023, are these firearms in common use? And if the answer is yes, you cannot ban them. It doesn't matter whether they existed in 1791, but you certainly would not come away with that understanding based on this article where they're trying to say, well, we get to discuss trap guns and Arkansas toothpicks and Bowie knives and air rifles and Lewis and Clark and so on, so on, so on. These are interesting points, but the reality is the only question when it comes to banning arms in modern day America is, are they in common use? And if they are in common use, which the things we're talking about banning, which is magazines that hold more than 10 rounds and AR-15s, clearly these are in common use. They cannot be banned under the Second Amendment, but this article doesn't seem to want to talk about those things. There's only two additional points I want to make about what I consider to be an earnest but slanted New York Times piece that's against guns. I would expect nothing else. I think it was kind of well written, frankly, from the point of view of the anti-gun perspective. And again, I'm not beating up the guy that wrote it. I'm sure he got his information from the people we interviewed, which appear to be almost all people on the gun control side, with the exception of one person. And so I'm not surprised by the slant of the nature of the article. But it's interesting that in the context of this article, he talks specifically about how Judge Benitez is a George W. Bush judge who basically talked about the importance of looking at the history and tradition as to what it is, and that we're not looking for truffles. And he, has required the state of California to make that voluminous submission of any law they think is justifying the modern day gun control laws. I think that's a good thing. Of course, notice the reason why I bring this up is that they mention specifically that Judge Benitez is a George W. Bush appointed judge, but then in a couple paragraphs down, they point out that one of the so-called gun rights expert, Ashley Lubinsky, who used to be at the Cody Museum out in Wyoming, she's an expert in one of the gun cases, according to this, specifically a federal case in Rhode Island. And then they go on to mention that judge in Rhode Island questioned whether or not she was a neutral person, but they don't mention the fact that the judge that was questioning whether or not Ms. Lubinsky was a neutral expert, they don't seem to question or mention the fact that was a Democratic appointed judge appointed by none other than Barack Obama. So they mention who appoints Judge Benitez, but they don't mention who appoints the judge that said that Ashley Lubinsky might not be neutral. They conveniently appear to have ignored the fact that guy was a Barack Obama liberal in Rhode Island. And by the way, Rhode Island is a federal district court. It's in the federal district court of Rhode Island is in the First Circuit Court of Appeals, based in Boston. In my view, that is the worst jurisprudence for gun rights in America. The First Circuit. I don't even know if you could get a two-judge panel in any combination that would be sympathetic to the right to keep and bear arms. They're all terrible in the First Circuit, as I see it, which is kind of strange because they include places like New Hampshire and Maine, which are actually pretty good on guns. But the federal courts in that part of the country, believe it or not, are just terrible on guns, as I see it in my view. The last but not least, they take an issue with Ashley Lubinsky by pointing out that she does not have a doctorate degree, but what they don't mention is that the story about Michael Bellesiles, who had a doctorate degree, was a tenured professor of history at Emory University, won the Bancroft Award, and of course all of his anti-gun so-called historical research in his book all turned out to be not true. But for some reason, this article is willing to reference the fact that Ms. Lubinsky doesn't have a PhD, but then at the same time seems to ignore this story of arming America. One wonders whether or not that came up, and anyone mentioned this to the author of this article, which is kind of well written, although I think slanted and misses some key points. Okay, folks, I'm going to post the link to the New York Times article, but again, as you know, I tried to talk about issues way ahead of time with you. We talked about the use of historians by the anti-gunners back in November and the fall of 2022. The fact that the New York Times is just getting around to this trend now really does help show you that I'm trying to get you guys out in front of everyone else in America in terms of protecting our rights. That is my goal. I want to make you the smartest person in the room, and that is my 100% goal, and that you are better than anyone in that room when it comes to our rights, including fancy-dancy people with fancy-dancy degrees and fancy-dancy credentials, because I will make you smarter than they are if you give me an opportunity. At least that's my goal. Okay, folks, hope you learned a little bit something here today. If you haven't subscribed, please do so. We'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.